The Supreme Court just handed down a 9-0 ruling that changes how your Fourth and Fifth Amendment rights work together during a police encounter. Every single justice agreed. And if you think you already know your rights, what I'm about to tell you may be the most important correction you ever hear. Stay with me. This one is different. Here is the case. Barnes versus Felix. It came out of Texas. An officer stopped a driver named Ashton Barnes over suspected toll violations, a routine stop. The kind that happens millions of times every year across this country. But within seconds, the situation exploded. Barnes began to drive away. The officer jumped onto the moving vehicle. He fired 2 shots into the car. Barnes was killed, and the legal battle that followed changed American constitutional law forever. Now, before Barnes, many courts across the country were using something called the moment of threat rule. Do not let the name confuse you. In plain English, it meant this. When a court reviewed whether an officer used reasonable force, some judges were zooming in on one frozen split second. Just the final instant. Just the moment the officer said he felt in danger. Everything that happened before that moment. Some courts were pushing it aside. The Supreme Court said no. All 9 justices said no. The court ruled that judges cannot put on what it called chronological blinders. They cannot stare at only the last second of an encounter and ignore the full story leading up to it. Courts must now look at the totality of the circumstances. That means the whole encounter. The reason for the stop, the commands given, the movements made, the choices by everyone involved, the entire timeline from beginning to end. That is a seismic shift. And here is why it affects you personally. Most gun owners, most drivers, most ordinary citizens never think about what their actions look like on a timeline. They think about the moment. They think about the final second. They think about what they said or did right before something went wrong. But after Barnes, the story starts much earlier than that, and the story includes you. Let me put this in a real scenario. You are driving home. You are carrying legally. You get pulled over at night on a quiet road. The officer approaches fast. He is tense. You are tense. He asks for license and registration. Your wallet is in your front pocket. Your registration is in the glove box. Your firearm is under your seat. You start reaching without saying a word first. You twist toward the console. The officer cannot see your hands clearly. Your passenger reaches for her phone to film the encounter. The energy inside that car spikes in 3 seconds. Under the old moment of threat standard used in some courts, a judge might have focused almost entirely on that last move you made. Did the officer feel threatened right at that instant? That is what some courts asked. But after Barnes, a court has to ask something bigger. What happened before that moment? Did the officer give a clear command? Did you follow it or not? Did you communicate what you were reaching for? Did anyone in the car make the situation more dangerous? Did the officer create unnecessary tension before the situation escalated? The whole film is on trial now, not just the final frame. And here is what nobody in mainstream media is talking about. That wider timeline cuts in both directions. If an officer acted recklessly or escalated unnecessarily before the final second, that now matters more in court. But if you, as a driver or a passenger, made moves that looked threatening, used an aggressive tone, ignored commands, or created confusion, that behavior is now a bigger part of the legal picture too. This is not just a ruling about lawsuits. This is a warning about behavior. Stay with me, because I need to connect this to the Fifth Amendment now, and this is where most people get completely turned around. Barnes is officially a Fourth Amendment case. The Fourth Amendment protects you from unreasonable government action, including unreasonable force during a stop. But the moment you are in a real police encounter, your Fourth and Fifth Amendment rights do not sit in separate boxes. They show up at the same time. In the same car, in the same 30 seconds. The Fifth Amendment gives you the right against self-incrimination. In plain English, the government cannot force you to help build the case against yourself with your own words. That is where the Miranda warning comes from. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. But here is the mistake millions of people make. They believe that if the officer does not read Miranda, then nothing they say counts as evidence. That is false. And that false belief can destroy you. Let me say it clearly. During a standard roadside traffic stop, you are typically not considered in custody for Miranda purposes. That is what the Supreme Court has held in prior decisions. Which means during an ordinary stop, an officer does not have to read you Miranda before asking questions. And most people, because they have not heard that warning, assume they are free to talk their way out of the situation. They talk. They explain. They overshare. They try to sound calm by being loud. They try to sound innocent by saying too much. And every single word they say becomes part of the full encounter. The same full encounter that courts must now examine under the Barnes standard. Barnes did not rewrite Miranda. I want to be absolutely clear about that. Barnes is not a Fifth Amendment ruling, but Barnes made the full encounter more legally significant under the Fourth Amendment. And the full encounter in real life almost always includes what you said, how you said it, how loudly you said it, and whether your words made things safer or more dangerous. Those two amendments are linked by reality, even if they are separate on paper. Here is a second scenario. An officer pulls you over at night. He asks, "Are there any weapons in the car?" You are carrying legally. In some states, you have a legal duty to inform the officer. In others, you do not. But instead of answering calmly, you panic. You say, "Why do you need to know that?" Then you start reaching toward your waistband to prove you are not hiding anything. Fast hands and a defensive tone in the same moment. That combination is one of the most dangerous things a lawful gun owner can do during a traffic stop. Under the Barnes framework, if that encounter later ends up in court, investigators are going to examine your words and your movements as part of the full timeline, not just the final instant, the whole thing. Now let me give you 4 things you can actually do right now to protect yourself. First, when you are stopped, keep your hands visible immediately, before the officer reaches your window, before he asks anything. Hands on the wheel, fingers spread, visible. That one habit alone can change the tone of an entire encounter before a single word is spoken. Second, speak before you reach. If you need to get your license from your wallet, say that out loud before you move. Say, "My license is in my front left pocket, I am going to reach for it now." That sentence takes 3 seconds to say. Those 3 seconds can prevent a catastrophic misread. Third, do not wait for Miranda to decide whether to stay quiet. You have a Fifth Amendment right to remain silent before Miranda is ever read. You can choose not to answer questions that go beyond basic identification. Some states do require you to identify yourself. Know your state law. But understanding that the right to stay quiet exists from the first moment of a stop, not just after a Miranda warning, is one of the most powerful pieces of legal knowledge you can carry. Fourth, control your tone. Courts are going to look at the full encounter now. Your voice, your attitude, your body language at the start of the stop, in the middle of the stop, and at the end of the stop, all of it can shape how a court interprets what followed. Staying calm is not just good manners. After Barnes, it is strategic. Now let me address something that may be in your mind right now. Does this ruling mean officers lose more cases? Not automatically. The Supreme Court specifically stated it was not ruling on who wins the Barnes case. It sent the case back to the lower court to be examined using the correct standard. The court did not declare the officer automatically wrong. What the court said is that the wrong legal test was used. The full picture has to be examined, and here is the part that will matter for years to come. The court also chose not to answer a second huge question. What happens when an officer's own choices before the final moment helped create the danger? If an officer made decisions that escalated a situation unnecessarily, does that limit his ability to claim the force was justified? The court left that question open. That is the next legal battlefield. That case is coming. More decisions are on the way. The rule got wider, but how wide, and exactly how it applies in every state, is still being decided in courtrooms right now. This is not an abstract topic for legal scholars. This is a practical warning for every person who drives, every person who carries, every person who has ever been in a tense moment with law enforcement and had to think fast. The timeline you create in those seconds is now more important than ever. Body camera footage, dash cam video, dispatch audio, your exact words, your movements, the officer's commands. Every second of that encounter now carries legal weight under the standard the Supreme Court just confirmed unanimously. That means the most powerful thing you can control is your own behavior in those early seconds, before things escalate, before panic takes over, before the situation becomes a court case. Because here is the truth. Most people who end up in serious legal trouble after a traffic stop did not plan to be there. They were just reacting. They were surprised. They were scared. They made fast decisions with incomplete information. And then the law took over and sorted through every one of those decisions. After Barnes, that sorting process goes deeper and wider than it ever has before. Knowing this does not just protect you from lawsuits or prosecutions. Knowing this changes how you behave in the moment that matters most. So here is your final takeaway. Barnes versus Felix is a 9-0 Supreme Court decision that rejected the moment of threat rule in favor of examining the full timeline of a police encounter under the Fourth Amendment. It did not rewrite Miranda or the Fifth Amendment directly, but it connected the full encounter, your words, your movements, your choices, to constitutional standards in a way that every gun owner, every driver, every ordinary citizen in this country needs to understand. Your rights exist. They are real, but they are only as powerful as your understanding of them and your ability to use them wisely under pressure. If this kind of clear, no-spin legal breakdown is something you need, subscribe right now. My next video breaks down exactly what to say, what not to say, and how to handle a weapons question during a stop in a way that protects you legally and keeps the encounter as safe as possible. Laws change fast. Court decisions change even faster. The people who get blindsided are always the ones who thought they already had it figured out. Subscribe, stay informed, and remember, this video is for education only. Laws vary by state, facts matter. If you are facing a real situation, talk to a qualified attorney. Your freedom is worth protecting the right way.